are not safe in child protective services, and they won't give them back to their loving families because they're making money.
This is a legal system that you're going into. And if you don't know the rules, you will be chewed up and spit out.
If I could say anything to a mother who just got their children detained, you're in a crisis. Yeah. Life feels like it's over. The most important thing is regaining custody of your children.
The child welfare system at its core is designed to protect children who need protection, okay? And that's key, is who need protection.
So social workers, out of fear, will remove more children rather than only remove those children that truly need to be removed.
It's okay. It's okay.
This isn't someone stole your car. Someone broke into your house. This is someone took your child, your flesh and blood.
It doesn't say on this order that it was not proven. It says untrue. True. I immediately knew that, okay, well, this ain't over.
Were there signs there? Were there no signs? Did I miss them? Did I catch them? At this point, I honestly don't know.
Families only get a finite amount of time to reunify.
I came into this field to help families, not destroy them.
The difference between the criminal system and the child welfare system is substantial. You have more rights as a criminal than you do as a parent.
Good evening, everyone. Welcome to Fight CPS, the Civil Rights Struggle. I am here with my guest, Jessa. Jessa, how are you tonight?
I'm good. How are you?
I'm good, thank you. So, Jess, tell me a little bit about yourself. Do you prefer Jess or Jessa?
Jessa.
Okay, Jessa. Who is Jessa? Tell me about yourself.
I am a caring person who just loves helping other people more than I should. I'm creative. I live in California. I love it here. Love music. Love cats.
Beautiful.
Yeah.
Okay. So tell us how did CPS become involved in your life?
So my sister, about 3.5 years ago, her 3 kids, young kids, were taken from her and the father at the time. But we are still kind of unsure on what the actual reason was. We kind of had some hint, I guess. But then they were placed with my mom, who is in her 60s, and it's in another state. So I wasn't able to be an option for them to be placed with me. But
so you were outside of California.
Yeah.
Okay.
Yeah. But I would try to go visit as much as I could to give my mom a break, because she already had like health issues declining, and she already has my other sister's kid in custody forever. So, but then my mom just dealt with the CPS issues for a long time, actually, for about this entire pandemic. And just this last October, CPS took them from my mom.
And you don't know the reason. So you don't know the reason why they took them from your sister. And you also, do you know the reason why they took them from your mom?
We're also a little unsure about that too, because the caseworker would, so these kids, they have very high needs, behavior wise. And so the oldest was having a lot of issues in school and would literally be called out of school every single day. And she's old enough to understand behavior. And so my mom, who's very organic and into natural things, tried this. I don't know the exact name or anything of it, but tried this supplement that I was told that it was approved by whatever what's it called? You know what I mean, right?
But are we talking about the FDA?
FDA, yes.
Okay.
And other doctors, I mean, she really gets into like learning about reviews and stuff.
Right.
And it was
It's
helping.
extremely important to understand the ingredients and these supplements that you're taking.
Yeah.
You know, sometimes something can be perceived as healthy, but you don't know how it's going to react with, like certain ailments that you might already have, your DNA. There's a lot of research that, we in our own due diligence have to do, which I'm sure he's done.
Yeah. And the caseworker didn't say anything about it because my mom would have to give them a list of everything that the kids were ever going to be on.
Mm-hmm.
And for a few weeks, it was fine. And then all of a sudden it wasn't. And this caseworker, I guess, the communication was very weird. And all of a sudden, but so I don't know if it was because of the supplement or because my sister also just sometimes randomly just is like, I don't want them with my mom. Just like changes her mind all the time. So then that happened, and then they were taken because my sister didn't want them placed with my mom.
Okay. So we've got like some familial issues kind of going on here. I mean, which is understandable.
Yeah.
And a mother would want her children to be back with her. But you have no idea why they took them from your sister.
Not the exact concrete answer. We were aware of some issues because of the father. And
are we talking domestic violence?
No.
Okay. Well, only share what you feel comfortable. I'm just trying to understand kind of what type of case we're dealing with.
Yeah. I mean, there's a few things. Technically, a cop showed up and saw some things in the home and were like, kids can't be there because it was unsafe. Certain things were just laying around. So I get that. But then we also heard something else. But there was a time where my sister was actually working towards getting them back and doing all the classes and doing everything CPS was having her do. And it was looking pretty good.
Okay.
And then something happened. And then, and then COVID happened. And then she just left our hometown. Like she just booked it and went across the state. And that made it very difficult because then she couldn't come to like any meetings, couldn't do anything, didn't have a home, couldn't get a hold of her. So then they were placed with my mom for some time. And that it was going okay. And then there would be like so much for my mom that she would have to try and get done. She was doing everything she could, trying to, be the responsible person to do what CPS tells her to do. And we've never dealt with this. So we're like, okay, we need to do what we're supposed to do,
Right. Now let's fast forward to where they're taken away from your mom.
Okay.
Do you have any idea what she was being accused of? What the basis for their case might have been?
A lot of it was the supplement of her just giving it to the child without permission.
Without whose permission? If she had guardianship of the children, it's, she ultimately had that discretion.
So at this point, we were still almost to actual guardianship. And the CPS kept telling us that we were actually almost there to where we would even be able to have the kids out of state to come visit me. But then my sister kept causing more problems. And it's hard to explain how my sister is because she is a fighter and she will just at the meetings, she would just go ballistic and start screaming, why aren't the kids with me? And it just made it look like she was just
unstable. basically, is probably what they're looking at.
Yeah.
And I know you wouldn't want to say anything bad about your sister, and I'm not saying that these people are good people, but it does sound like a really complex type of situation. Now, did these supplements, like, did they have CBD, hemp, cannabis, anything like that in there?
Not like that, but it was definitely, even the child was like, because she knows when she was having a hard time, she would explain it like, I just start shaking like this. And then when I take those, I feel calm. And it was so cute. Like, I can picture her, she'd be like that. And even the school would, say she was improving. And the school was actually on her side. They wrote letters and stuff. But when we were told by the caseworker, after some time of her having this, that, oh, now it needs to be stopped, he never ever said anything on the reasoning. And my mom really tried to get him to explain it so she could understand. She agreed to stop it. But then it just turned into this whole thing.
Of course it did. I mean, this is what these people bank on. So where are the children now?
So when they're taken in October, they actually took all 3 kids so they're in a tribe as well. So I don't know. That makes it more difficult. So that means,
like an Indian tribe?
Yes. They have that.
I cannot tell you how many cases I've heard where indigenous, peoples were very much targeted and manipulated. I was interviewing a woman once, and she said they snatched her kids. They literally stole her kids without any basis. And they said that they would reinstate her license that was suspended for, I guess, failure to pay a ticket or something. They said they would reinstate her license if she agreed to give a DNA sample. And I saw one, she sent me a piece of paper where I did see that she had a DNA sample taken by the city, but there was no record within the city that they had done this. They had completely expunged the entire thing, the whole deal. It was very odd. And then they resuspended her license, and then they were following her around, and they pulled her over and took her children. It was insane. It was insane. But I've heard several cases where they were indigenous and they were a part of a tribe, or they were on what do you call a reservation, and they had their children taken away. I'm really sorry to hear that you're going through that.
Yeah. So they took them, and in the tribe they have, I guess, a lot of say in where the kids are placed. So they are only allowing the kids to be with Native American families. And so they moved the kids actually across the entire state with a family they never met ever. And that family was only able to handle them, not even for a month. So then they removed them, brought them back to the hometown, and the 2 youngest are with a family friend of ours.
That's
which
good.
We love dearly for putting up with this. And she's starting to get as frustrated as my mom did, because she's like, I can't believe you dealt with this. Because they're making up excuses on so many things. But the oldest child is with another family a town away, and we can't have contact with them.
Now, the oldest child, that's the one that was having issues in school?
Yeah.
What I don't understand is, if you found a natural FDA-approved supplement and nobody had an issue with it before, and it did actually help the behavior, why is it an issue later on? Why would it be an issue now? And furthermore, what really upsets me is that these people who are supposed to be trained in dealing with children fail to understand that perhaps the mother had a chemical imbalance, and those chemical imbalances are directly passed down to our children through our DNA.
Yeah.
It's not like she's a bad person. She just needed a little bit more help. Obviously her child needed a little bit more help, and your mom was able to give her that help. So where's the fucking problem?
I know.
So tell me,
we even had a doctor from the kids' clinic that they went to. she was on our side as well and was writing a letter. The principal of the
So
school
the
was writing a
doctor,
letter.
you have
Yeah.
a licensed practicing doctor. Okay. Do you know where you are in the case right now? Have you been able to go to any of the court dates? You said it was outside of the state. Are you comfortable telling me what state it's in? Washington State. Okay. I'm not really familiar with the CPS laws in Washington State. I do know, I am somewhat familiar with the California state laws. Have you considered filing a motion to intervene?
No.
If you feel that you're capable of caring for these children and taking custody of them, sometimes what a parent, disclosure, I'm not a licensed attorney yet. I'm not giving you legal advice. Don't take it as legal advice. I'm simply providing legal education, which we all as citizens have the right to. So sometimes in cases like these, as a family member, I mean, you can petition to CPS to take custody of them. And obviously if that's not working, you can go straight to the courts and file a motion to intervene.
So the last time I was involved with one of them, it was the Zoom court hearings for the placement. It was right before the kids were placed, like in Seattle, totally opposite. I did ask the judge, and I was like, "Can I be an option? I know I'm out of state, but I will do this." Like,
now, where did your mother live? Did your mother live in Washington State?
Yes.
Okay, so that's why they had jurisdiction. Okay. This is kind of a complex case. So what is your goal? What is your goal with this case in your relationship to your sister's children?
I am going to do my best to fight with my mom and get these kids under my care, because they're fighting against us having them under my mom's care. But it's kind of tricky because I'm afraid of the tribe right now, because they're using, I'm not Native American, so I can't be an option. And so they're reaching out to the father's family that don't even know the children. And they've already said no. Twice.
Recently, there have been some laws that have passed. I don't know how that relates specifically to indigenous tribes, but I do know that there were recently some laws passed that are really pushing, to expand who is a viable option for children to be placed with. So before, they were very reluctant to place them with homosexual parents, or, parents of certain ethnicities or classes. And they've been fighting back, and there have been some laws passed that make it borderline illegal to discriminate based on things like that. And that might be something that you want to look into.
Yeah.
But if the case is in Washington, you're going to want to look at what your rules are and your laws are specifically to the jurisdiction of the case, which is Washington State. And if you know what city the case is in, you want to look at the rules and the laws specifically for that city.
Okay. So my recent update, though, from the family friend who has the two youngest, is that the family that has the oldest wants the oldest to be removed already. So we're just kind of waiting, because we don't know what's going to happen with the oldest. The friend wants to see if she can get the oldest as well.
I don't know how much you follow our shows, but Vincent Davis very often talks about one thing that you can do, which is you can send the caseworkers, and by law, they have to listen to this, and you can seek damages if they refuse to do this. If you send them a list of 25 family members and friends who are willing to take custody of these children, and they ignore that, there could be some consequences for them. If you can think as many people as you can think of, they don't have to agree to immediately take them, but just having that list and sending it to them, they have to respond to that. If you can think of 25 people who would be willing to take these kids, and you send it to this caseworker and it gets ignored, there could be serious consequences for that caseworker and their supervisor.
Wow. I didn't know that. Because the whole time I'm like, why aren't they reaching out to me? Because I have said at the meetings that, yes, I will take them.
It's not uncommon for pleas like that to be ignored. In fact, it's very common because they get more money, they get more grants if they place the children in foster care or with people outside of friends and family.
They did say, though, recently that they will never drop the parents' rights. So as long as they say they can't be placed with whoever, they're keeping it like that.
So they're not trying to terminate her parental rights.
No.
How long have they been removed from your mom?
Since this last October.
Okay, so we're coming up on a year. A lot of these cases are time sensitive. You know, you have between 15 and 18 months to really like have a final decision made on your case. Or, you know, just like they did before, they could, on the turn of a dime, completely switch up their motive. They might be saying one thing now, but they could definitely change their mind down the road. So just be aware of that. I don't want to be the bearer of bad news, but it's important to be aware and to be very careful and to be very diligent in doing everything that you can, and your mom as well. Like I said, consider a motion to intervene. That could, you know, at least it could get you your day in court to be in front of the judge. So you can tell the judge yourself, listen, I'm capable, you know, I'm willing to take custody of these kids. You know, I am her sister. I'm their aunt. There's no reason not to let me take custody.
Even if I'm out of state and they're
even if you're out of state, you would have to file it with the courts where the children are. So whatever court is hearing this case, you would have to file that motion with them.
Well, my mom and my other niece that my mom and I share custody of are moving here with me.
That's exciting. That's good to hear.
We can't wait to get out of that state. So our plan was we're going to get a house, and I told her about Vincent. I was like, we should just hire him.
That's an excellent idea. He has a, you know, a few different options. If you can't afford his full retainer, he does phone consultations. You can do like a partial fee where he'll work up to 5 hours on your case. You know, he'll file some motions for you. He'll talk to the attorneys who are working on your case and just make sure everybody's on the same page. So definitely call his office and see about, you know, what your options are.
Okay.
And he does amazing work. You know, he is, I would say personally, the most famous and capable CPS consultant in this country, at the very least in this country.
Yeah.
I have so much respect for him, and he really does care about his case and his clients.
Cool. When this all first started, he was the first person I found on here, and it's because of him I found this. Does he take out of state cases though?
He does. Yes, he does.
Okay.
Yeah. I wish I could give you advice, but I can't. But I mean, this case definitely is complex. Like, what is your long-term goal? Is your sister getting visitation with the children right now? Is she able to see them at all?
Well, sometimes on like Zoom, because she refuses to go back to that town because a whole other thing. So she's never gonna come in person.
That's not helping her case.
I know.
She needs to swallow her pride and be there for her kids.
I know.
Now, I can say that. That's not legal advice. What about you? Are you able to see them at all?
I can only have Zoom with the two youngest. I haven't had any contact with the oldest yet.
Vicky, thank you so much for that comment. Actually, as a matter of fact, I've got a little treat for you guys. So I was talking to one of my dear friends today. She is a constitutional guru. She literally ran like, oh, I can't even tell you. I've met her in person and I saw the video myself. It was insane. She ran like 20 fucking cops and some CPS workers like straight off her property. They tried to come and get her. She was like, no. She came outside reading the paper. She was like, have you read the Constitution?
Oh my gosh.
It was awesome. She just started a new show called Boom, Back Off of Me. So she's got a YouTube channel called Boom, Back Off of Me. And she just gave me some information today. So there is a family law justice center in New York. However, they do have information for possible funding in other states. So it's worth looking into. And that number is here. I don't know. Guys, have a pen, take this down, replay this later. Okay, so there is possible help for lawyer fees, and that number is 866-534-4602. Again, that's 866-534-4602. Another organization that you can look into is the Family Law Justice Center in New York, but they do have other out-of-state resources. So that could be some hopefully valuable information for you guys. I will be looking into them myself.
Cool. Thank you.
Of course. And thank you, Vicky. Yes, she's
yes, thank you, Vicky.
You know what? One of these days, I'll have to give you guys the link to the actual footage. I mean, because she was able to get a copy of the police officer's body cams. She had the police sergeant on her front porch, and she was just telling him off. And he knew, like, knowing your rights is fucking paramount. It is imperative that you know your rights, because if they realize that you don't know your rights, you might as well not have any. They're going to violate all of them. And once your rights are violated,
it's over pretty much.
It's a completely different ball game. It is. It is easy to know your rights and get them the fuck out of your life in the first place and not let them in than it is to try to backtrack and fix what was fucked up because you didn't know your rights. So that's very important. I do have a couple of pieces for our legal education today, but I want to go ahead and finish with you.
Okay.
So other than the little bits of education that I was able to provide, do you have any additional questions, comments, concerns?
So for me, it's really hard to like learn my rights because there's so many places you can look it up at. Is there like a really good education website that I can really, I guess it would depend on, because it's separate, right? I would have to learn Washington's rights and then also California eventually.
There are a lot of different layers to the law that you have to learn. I am just beginning my journey as a legal scholar, and I have so much to learn still. I've been in school. I've been reading the law for years, and I've been in school for a couple of years now, and I'm just scratching the surface, honestly. Vincent Davis does have a course that you can get. He also has a book. Oh gosh, I just moved into my new house. I didn't just move in. I moved in a few weeks ago, but I'm still unpacking everything. I don't have the book in front of me, but he has I think it's called The Secret: How to Fight CPS and Win in the book version. And if you reach out to Georgette Truen, his legal assistant, she'll be able to provide you with a copy of that. There's another course that I really enjoy, and it's Jurisdictionary. I have personally met and am acquainted with Dr. Frederick David Graves. He's a great mentor. His course teaches so much. I mean, I'm still kind of diving into his course as well. So there are a couple of different options. These courses do cost money. The one that I bought, Jurisdictionary, cost me $250. That's for the first year. And after that, it's $89 for each consecutive year. Vincent Davis has his course. Let me see if I can look this up. Here. If it's not posted, it is still in the making and getting ready to be posted. Let's see. Okay, I'm not seeing anything right this second, but let me get with his legal assistant and see if I can get you guys that information. I can post it on the page.
Okay. All right. Cool.
Yes. Now, before we go into our legal education portion, do you have any more questions for me? I do have a couple of wrap-up questions for you, but you can stay on while I do the legal education in case you have any questions, or I can go ahead and let you go for the evening, whichever you prefer.
I don't have any questions now. I'm good.
Okay. So So before we close, what could you tell our viewers as far as advice that you have learned over the course of this case that you didn't know before? If there's another family that's kind of in your shoes dealing with a similar situation, what would your advice be to them?
That you have to be careful on what you say to CPS, because it will get used against you or twisted somehow.
Yeah, I know that's right. I know that's right. Shit.
Yeah. And you I think, at least for us, you tend to go through caseworkers. Like, you don't just have one. They come and go. And I don't know if that's a thing, but
I've heard that a lot. I've heard that a lot.
Ugh.
Now,
there.
if the children were listening right now, what would you want them to know? Is there anything that you would like to say to them?
It's unfair what's happening, but know that we're gonna fight and do what we can to get you back. It's very confusing. We'll explain it to you when you're older. I'm sorry. Love you. It's not our fault.
I'm sure they understand that. And I really hope that you guys are able to get the answers and the help that you're looking for. Just remember that you are part of a great support system now. Feel free to reach out to me at any time, or Georgette, or any of us here with the offices of Vincent Davis. And I would like to have you on in a few weeks to see if there's any progress. Okay. Do you know if there's a court case pending?
I can ask.
These are things that you really want to be on top of.
I don't get any information other than when I ask for an update from our family friend. She'll tell me what's happening. Okay. I can ask if I can be reached out to.
Definitely assert yourself in this case. Make sure that your name is there and that you're known and that you are a party that's being included. Also, I would ask for copies of the paperwork. Now, unless a parent files a motion to intervene, if they're not on a party to the case, especially if it's a juvenile case, they're not going to be immediately privy to that information. So, a parent in that situation, it would be very important for them to make sure that they become a party on that case, at least try the best they can. And that is a method that has been successful in the past.
Okay. I just got a question real fast.
Of course.
Because we've also learned that my sister will hear things about what we have not said. And then it just caused more stuff against us because
they're playing you guys against each other.
Yeah.
Don't let it rile you up. They're trying to just rip this family apart as much as they can. It's what they fucking do.
Yeah.
Because they're evil. So just, I would say personally, my advice would be to try to be as open and close with your sister as you possibly can. I know she's going through a hard time as well. I would check in on her and make sure that, she's not being self-destructive. If you find that she is, just try to be as understanding as you can. Maybe, if it's absolutely extreme, I guess get her help. But I can tell you from experience, it gets really hard to keep going sometimes. It really does, especially as a parent who's had their flesh and blood ripped away from them. You're stripped of all purpose. Everything that you love in your life is just gone. So make sure that she's okay. And, I don't know the details of how your relationship is with her, but just kind of, being as supportive and honest with her as you can will help, keep that relationship intact while you guys are under attack by this child trafficking industry.
I'll try again.
Just
it is
know
kind of
they're
hard
putting
because
you
she's
guys
blaming
against
us.
each other intentionally.
Yeah.
And try to help her understand that.
as much as I try and be like, look, Erica, I don't know what. Oh,
It's
sorry.
okay.
I don't know.
It happens.
I don't know what they have told you, and I'm sorry this has all happened. And I always say, like, look, we can talk this through. And we've tried so many times, but she just can't. Like, she attacks, and then she doesn't speak to us forever. And then it's just a cycle. And because of the decisions that she's made to where she's at now, like, we don't really know exactly where she's at.
Okay.
She's put herself in a situation to where she might not be safe.
That's often what a chemical imbalance can lead to. She's going to have to, I mean, if you can't track down where she is, she's going to have to find her way
to find her.
Yeah.
I don't know.
I don't know if you're religious. I'm not really anymore. But I don't know, like maybe manifest good intentions, like good energy, pray if you pray.
Yeah, I manifest and write affirmations over and over, thinking about her. Yeah.
That's good. I'm sure it helps. I mean, it definitely does at least something.
Yeah.
I'm sorry again that you're going through this, and I hope that you guys are able to find some answer soon. And if you need to go over anything that I talked about today, just when the live is over, you can play this video and go back to it as many times as you'd like.
Oh yeah, because it's posted the next day or soon after.
Yeah, as soon as I end the live video, it's ready for you to view again.
Oh, cool. Okay.
Yes. So you can pull this up as many times as you need. And anybody who didn't get that number, just watch this video again and the number will be there. But to be nice, I'll say it one more time because somebody commented, what's the number? That number is 866-534-4602. And that is help with lawyer fees. So, Jessa, I want to thank you so much for coming on tonight. I wish you the best of luck. Keep in touch. I want to hear how your case is going. If you have any additional questions, let me know. Definitely get in touch with Georgette Truin, his legal assistant.
Okay.
And you can reach her at 888-888-6582.
Okay. All right. Thank you.
Of course. You have a great night, Jessa.
You too.
All right, guys. So we are going to move into our legal education portion for the evening. Last show on Monday, I was talking about how to team your lawyers, but I wasn't able to finish the whole course. So I'm going to go back to that. So first off, we're going to talk about so lawyers who don't work for a percentage of the outcome typically bill in 1/10 hour increments. If you phone the lawyer to ask a question about your case, it'll cost you 1/10 of the lawyer's hourly rate, even if the lawyer only talks to you for 20 seconds. If you email the lawyer, expect to be billed for at least 2/10 of an hour. 1/10 to read your email, 1/10 to answer. All right. So lawyers have just two things to sell. That is knowledge and time. Though all you need to win in court is education and a few hours of your time, lawyers have to pass the bar to represent their clients. To pass the bar in nearly all states, one must graduate from an accredited law school. That typically is 3 years of study and more than $100,000 for tuition and books, not counting the cost of housing, food, and other expenses. Time, therefore, must be billed or recovered as a percentage of successful judgments, and it is rare these days for a lawyer to charge less than $300 an hour, more than 20 times what most people earn for 60 minutes of work. This is why you must know what your lawyer is doing, why it is necessary to be done, and what your lawyer plans to do going forward before you are billed for the time. Much of what lawyers do is not necessary to win for you. Require your lawyer to keep a timesheet wherein she or he records what he or she does to advance your cause and how long he or she spends doing it. Require the lawyer to provide these timesheets before you are required to pay the bill each month. If the timesheet indicates a half-hour telephone conference with opposing counsel, demand to know why it was necessary to spend so much time, what was discussed, etc. If you're paying for it, you have the right to know. And let's talk about why do lawyers take depositions too soon. All right. Nearly everything you need to learn from your opposing party or a non-party witness can be obtained in writing at the cost of a few hours drafting documents and a few dollars in postage. And I assume that they are talking about requests for admissions, requests for production, interrogatories. Those are some 3 very, very valuable and not that expensive discovery tools. Still, it's commonplace for lawyers to start off on a new case by scheduling depositions instead of using the written evidence discovery tools. If you are paying a lawyer by the hour, do not put up with this. After the written discovery methods are used, it may be necessary to take a deposition or 2 just to clear up any loose ends. If your lawyer chooses to depose you or non-party witnesses, do not fail to attend to the depositions. Do not let your lawyer ramble asking questions that have nothing to do with your case. Depositions are intended to get answers into the court record, not to visit with the opposing counsel or get chummy with a witness. If you're paying your lawyer, hold his or her nose to the grindstone and put up with no nonsense waste of time and your money. So, a lawyer's typical workday. Any lawyer worth his or her salt will spend time doing legal research, guys. Drafting documents, and on occasion attending hearings or preparing for trial. Everything else is a waste of your money. And as far as professional responsibility standards, every state bar is set up to discipline lawyers who do not obey the professional responsibility standards established by the bar. They may be called something else, e.g. ethical standards, etc. However, every lawyer is required to abide by the published standards. You can find these easily, but using Google to search for your state bar's website. You will find a host of information there to help you control your lawyer and possibly to put a bit in the mouth of your opposing party's lawyer if he or she is in violation of the rules. First, of course, you need to read the rules on your state bar's website. Again, guys, educating yourselves is so incredibly important, or you will be chewed up and spit out by these courts. Now, the next thing that we're going to talk about this evening is how to persuade judges. So we learned how to tame our lawyers. Let's learn how to persuade our judges. So the first rule when dealing with judges is that they are human. Though at times you may think the judge in your case is a gorilla wearing a black robe. Some are, but most are not. Every day you find yourself in front of one in the courtroom. Stop a moment to recognize the judge woke up this morning just as you did, has family and loved ones just as you do, and is faced with the same mortality that faces us all. The judge or judge's family member may have a life-threatening disease weighing on his or her mind. The judge may have another case later in the day that will require dire decisions far more important than the ones involved in your case, though decisions in your case seem more important to you. You never know. And sometimes the judge may care more about you and seeing that justice is served in your case than you have it yet imagined possible. The judge may have decided to rule in your favor even before hearing the facts or researching the law, depending on what the judge thinks of you as a person of honesty and integrity, or what the judge knows about your opponent's reputation for dishonesty and deceit. It happens. Judges come in all shapes and sizes, and no two are the same. Most are good people. Most are trying to do what's right in every case, as far as their judicial knowledge and experience will allow. None are perfect, however, but then neither are you or I. So expecting a perfect judge is hoping for the impossible. The best you can do is expect the worst, prepare for the worst, and at the same time, be wise enough to know you are dealing with a human being who responds to both respectful kindness and demanding rudeness just the same as you. The former favorably, the latter with disdain and determination to thwart whatever is being sought. Politeness and kindness work in court too. Be respectful and kind, even if your judge seems to not deserve it, because the judge will decide the outcome of your case, and rudeness or demanding attitude will only work against you because judges are human, just like you. So they say. The golden rule applies in court as elsewhere. Treat the judge as you wish to be treated, and thereby maximize the possibility the judge will treat you as you wish to be treated. Seeing humanity in the judge on your case is possibly the most important thing you can do because your attitude toward the judge will be favorably flavored by your willingness to see the judge as a human being with needs and wants like everyone you meet in life. The judge will sense your attitude, positive or negative, whether you express it in words or just by facial expressions or the irritable way you rustle your papers or drop your books on the lectern with a bitter-spirited bang. You will not win if you cannot get the judge to do what you want, and you cannot get the judge to do what you want if you don't handle the judge as I teach. Your case will be won or lost entirely on how you handle this judge, no matter how much evidence you think you have or how much you think the law is on your side. Judges rule. Getting them to rule in your favor is your goal. So, how do we get heard? Some judges have been caught reading newspapers on the bench. Some have been caught fiddling with their laptop computer. Sometimes they fall asleep. Speak up. Ask, did I make that last statement clear, Your Honor? Get and keep the judge's attention. Ask, would it help if I spoke a little louder, Your Honor? Ask things politely, of course, but get the judge's attention if the judge seems to be wandering off in some daydream or thinking about a game of golf he or she wants to play after work, or the disgruntled wife he may have to face when he gets home in the evening. Understanding and working with judicial humanity is just as important as in-depth legal research, incisive motions, persistent discovery requests, and everything else. If you don't have the judge's attention, you may be making the record. You did arrange for the proceedings to be taken down by a court reporter or recording and made certain you get a transcript if you need one, as we emphasize again and again. And what I say, always have a stenographer, guys. Always have a court reporter, and make sure you get those transcripts. If you can't afford them right away, they will hold them for, sometimes several years. But if the judge isn't paying attention, you run the risk of losing and being required to appeal, which is a long, tedious, and usually expensive process that can be avoided by making certain the judge is listening when you speak. Make eye contact and hold it when you speak to a judge. One excellent tactic that you can employ is to ask at the beginning of every hearing, did Your Honor read my motion? If the judge says they have, then argue the motion as you would normally. If the judge says they have not, for whatever reason, then read out loud the critical portions of your motion and citations to case law, word for word, so the judge hears your arguments and knows what you are seeking with your motion. By reading the critical portions of your motion, there is no doubt of the judge's knowing what your motion is for and why the judge should grant it. If you don't read it, you're shooting yourself in the foot. At every trial and every hearing, it is critical that you get and keep the judge's attention when you are speaking. If the judge's attention wanders when your opponent or his witnesses are speaking, that's no skin off your nose. So let it work in your favor. Don't do shit about it. You are never required to help your opponent, so never fucking do it. If the judge looks away from you while you are speaking, pause until you have his eye-to-eye attention once more. If he continues to look away, be bold to ask, may I have the court's attention, please, Your Honor? Don't fall victim to the common practice of lawyers who refer to judges as judge. Don't do it. Refer to the court as the court and to the judge as Your Honor. It may seem like a small thing, but it can play big dividends. Everyone has an ego, and everyone responds positively to respect. Always be respectful, even if you don't feel it. So let's talk about making objections. When an error is made by an opposing party, a witness, or the judge, jump to your feet as quickly as possible, preferably before the entire error gets onto the record, and say loudly enough to stop others from speaking, objection. If you know the grounds for the objection, state them then and there, such as objection, hearsay. The affiant is not in the courtroom to be cross-examined, and I cannot cross-examine my opponent's piece of paper, so no matter what it claims to prove, the affidavit cannot come in as evidence, for example. Much more about courtroom objections later. What you want to learn is how to handle the judge when making objections, how to make certain the judge understands your objection is going on the record, and that you are not going to allow the error to remain without objection. But as stated in the previous section above, this must be done both forcefully and respectfully to be successful and timely. You do not want to be required to appeal, and if a judge overrules your objection And by doing so, jeopardizes your case or causes you to lose, the only option you have is that long, tedious, and usually expensive process of appeal. There is a way to speak forcefully without being harsh or accusative. You must be heard when you object. You must try to object so promptly that you stop the error before it makes its ugly, unwanted mark on the record. But you must also persuade the judge to recognize you are a kind and honest person who respects the court and not some belligerent child demanding that the judge respect you. If you want a judge to respect you, show the judge respect first, even if the judge is one of those biased gorillas in the black robe. Remember the human factor. Human emotion is flexible. Gorillas can be converted into docile lambs when handled with respect and polite demeanor. They can also be converted into raving monsters by rampant disrespect and open displays of contempt for the rule of law. If a judge overrules your objection again, object again, and if that fails, make a verbal motion. Failing that, draft and file a written motion for new hearing or reconsideration as soon as possible, keeping in mind such motions do not postpone the deadline to appeal in many jurisdictions. If the judge gets angry, say, let the record reflect that the judge is raising his voice and shaking his finger at me. It's your case, and you are the one with skin in the game, so to speak. Reserve such open displays of defiance for only the most extreme cases, though, of course. Stay respectful as long as you can. But when it becomes necessary for the appellate court to have a record of appealable judicial injustice or improper judicial behavior, only you can make the record clear on that point. If the record is not clear, the appellate court will not know what happened. Always try to do everything with respect for the court and the judge as much as lies in you to do so. So lastly, before we conclude, let's talk about getting orders. The whole purpose for going to court is to get the judge to sign orders. There are orders resulting from motions made by you or your opponent. There are orders judge may sign on his or her own. And of course, there is the final order of judgment that closes the case, either in your favor or in your opponent's. Most orders result from motions made by you or your opponent, and in most cases, follow hearings on motions where you and your opponent appear before the judge to argue why the judge should grant or deny a motion filed by either of you. A problem arises at the end of a hearing when the judge has not made an order, either in writing or verbally on the record. You are following, I hope, everyone. Many times you may attend a hearing at which a judge never makes a decision and may attempt to terminate the hearing without making a decision. In such cases, say, Your Honor, before my court reporter puts away her equipment, can we get a ruling on my motion? Or if it's your opponent's motion, say, Your Honor, before my court reporter puts away her equipment, can we get a ruling on my opponent's motion? Try not to leave before an order on the motion is stated, and make certain whatever the judge says does indeed constitute a clear decision one way or the other. If the judge refuses to make a decision one way or the other, say, I object to the court's refusal to make a decision on the motion, and see to it that the court reporter or recording will be able to provide you a transcript if judge's failure and refusal to rule work against you at some later stage in the proceedings. Some judges tend to be a bit wishy-washy, not wanting to decide much of anything they can avoid. But you are in court to get decisions, and it is the judge's bounden duty to make and state those decisions. That is the judge's job, after all, guys. If you succeed in getting a decision stated, immediately ask, May I prepare the order, please, Your Honor? Do this before your opponent asks to do so. Be a transcript that proves what the judge actually said and file it with a motion to strike your opponent's proposed order. So act quickly. If you're allowed to prepare a written order, make certain you use quotation marks around what the judge actually said and when the decision was pronounced, lest you get into a spitting match with your opponent that gobbles up time that lawyers love to bill for and not infrequently will play their cards to keep a case going as long as possible so they can make more money from their unsuspecting client. Remember, the name of the game of law is getting orders. So lastly, let's talk about writing orders. Many judges insist on writing their own orders. In fact, most who do so will rely on their clerk to do the writing. And many times the written order, especially if written by the judge's clerk or by a judge after a long delay during which the judge forgets what was decided, will not say what the judge actually said at the hearing. Guys, I'm a living testimonial to this. So as stated above, whenever possible, be the person who writes the proposed order for the judge to sign. When doing so, Unless you took accurate notes and know for certain what the judge actually said, order a partial transcript that is the official record of what the judge said. So know how the judge ruled and prepare the proposed order as closely as possible, if not exactly, to what the judge actually said. A copy of the proposed order should be provided to your opponent by mail or fax or whatever means your local jurisdiction requires, and a set of 3 proposed orders that should be sent to the judge with a cover letter stating that you provided a copy to your opponent by mail or fax or whatever is legally allowed under like your certificate of service in your jurisdiction. That's very important. Otherwise, you could get in trouble. So pay attention to that, guys. All right, so that is the proper way to do this very important task. Do all in your power to prevent your opponent from offering to write the proposed order, and don't be surprised even after the judge gives you permission to write the proposed order if your opponent goes ahead without permission to write his or her own version, which frequently will be inaccurate and favor your opponent contrary to the judge's actual decision. As stated, litigation is a fucking axe fight. Your opponent must never be trusted, though he or she cajole you, ask you out to lunch, make extravagant promises, do anything, whatever, to win you the idea that he or she can be trusted. Your opponent cannot fucking be trusted. The judge cannot be trusted. Never forget this, ever. So let's talk about the oath of office trap. In every jurisdiction known to this course, every judge must also be a lawyer and a member of the bar. And to be a member of the bar, every lawyer must take an oath and swear or affirm that he or she will abide by the rules and support the Constitution, along with a number of other things, such as never to mislead the court, to always keep his or her client's secrets, etc. There was a really good movie with Tom Cruise in it. It was like an older movie. And he was a lawyer, and it was like this like crazy weird firm that was like killing people. It was a really good movie though. I'll have to post it on the page when I remember what it was called. Failure to take this oath prevents one from entering the bar, from practicing law, and in most all jurisdictions from sitting as a judge in a trial level court. One may be appointed an administrative judge in some cases without being a member of the bar, but to sit as a trial judge, nearly all states require judges to first be admitted to the bar, which happens at the very moment when they take that all important oath. That doesn't mean every judge or certainly every lawyer actually abides by the rules or supports the Constitution in all regards. However, it does mean that each has taken an oath to be admitted to the bar and as a bar member to sit as a judge. Some people think they can win their case by demanding to see a judge's oath of office, believing if they can prove the judge has no right to sit on the bench, they can prevail in their case by claiming the court lacks jurisdiction to rule. This may work in minor cases like traffic violations or misdemeanors when the judge decides it isn't worth the time and trouble to get into a spitting match with someone who insists on seeing the oath. But in all serious cases involving large amounts of money or the threat of lengthy jail terms, it will not work in the miraculous magic hoped for. The judge, in your case, sitting on the bench, has legal power to issue warrants directing the sheriff or federal marshal to arrest and take you into custody, to have you jailed for contempt, or to simply rule against you without even hearing your case. At the very least, demanding to see the judge's oath of office will mark you as one of the increasingly ubiquitous anti-government people who think they are above the law because they read somewhere on the internet or in some blog or email that they can avoid the court's power by various means, such as demanding to see the judge's oath of office, raising some argument about his or her name being spelled in all capital letters, insisting the court in its admiralty court because someone placed a flag with a yellow fringe in the courtroom, which is improper flag etiquette, but in no way alters the power of a court rule. So that's like another thing that I've read. Like if your American flag in the courtroom has like the yellow fringe on it, it's not like a real American flag. It's kind of stupid, honestly. Like that's going to fucking make a difference to this corruption. I don't think so. So if you want to win your case, do what we teach using proper pleadings, motions, discovery of evidence, and the many other processes explained in the other classes, and avoid the temptation to try any silver bullet solutions you've heard about on the internet. It will only hurt you guys. People who think they can evade the power of the court system with such tactics frequently end up enjoying their meals behind bars in company with individuals who may not be as nearly sociable and friendly as you'd wish. So don't do it. Then, if you have a winnable case with the law on your side and evidence to support what you allege in your pleadings, you will win. You should win. I can't say will, but you fucking should. If you don't have a winnable case, or if the law on your side or the law on your side or evidence to support what you allege, giving the judge a hard time over his or her oath, or the fringe on the flag, or your name in all capital letters, or any other such nonsense will not change the outcome and will very likely result in adverse circumstances that you will not enjoy. So in conclusion, judges are human beings with awesome power. Wise people do everything possible to get that power to work for them and not against them. Most judges are reasonable men and women, though a few should be removed from the bench, disbarred, and forced to work in some other field of endeavor where their bigoted biases and giant egos cannot harm innocent people. That being said, when you find yourself in need of getting a judge to sign orders in your favor, the best course of action is to handle the judge with care, keeping in mind the insights offered in this class and presenting your case in accordance with all the teachings that we're going to talk about. So keep in mind what life would be like if we had no judges to control the bad people in this world. Criminals who would do harm to us and our families, or crooked companies and underhanded individuals who would rob us of our rights and leave us forever hopelessly lost with no court from which we could seek the law's help. Our system of government may not be perfect, but it's the best possible considering the pervasiveness of human nature and the necessities of some method to promote law and order and thereby preserve the peace and promote the welfare and tranquility of innocent people and their children. As every school child knows, our government, state and federal, is composed of 3 branches: executive, legislative, and judicial. What you may not know is that the judicial branch has more power than the other 2 put together. So handle your judge with care and get the justice you deserve. And we are a few minutes over time tonight. In conclusion to what I just read to you guys tonight, I do want to state what this doesn't say, and that is that our 3 branches of government, who are supposed to be separated, separation of powers, have become extremely intertwined, and that's a huge issue. I see a travesty of checks and balances. And that is something that I would like to address later on in my career. And I would like to talk about that more in the future. But like I said last show, if you guys have anything that you would like to learn about, send me a message. Let our producer Grace know. Let Vincent Davis's legal assistant Georgette know. She is my supervisor. And I would be more than happy to do some research and use that as part of our legal education. So anything regarding the law or government that you guys want to learn more about, let me know, and we will pursue it. And also join me tomorrow morning at 9 a.m. Eastern time. That's going to be 6 a.m. Pacific Standard Time. It's going to be Fight With Me Fridays. We're going to talk about mental health. We're going to talk about dealing with our trauma and keeping ourselves mentally and emotionally intact while we are enduring these horrific CPS cases. So thank you everyone for joining me tonight, and you guys have a wonderful evening. Good night.